Okay, should we start?
Yes, I think you should. 4 o'clock now.
Yes, sir. Yes, sir. Please, sir. My request, sir.
Good evening, everybody. This is the lecture on leading cases. Now, there are 64 leading cases. So we have divided the 64 leading cases into 4 bunches. So they consist of 16 judgments each. So I will be doing the judgment numbers, and if you want to make a note, the judgment numbers are 2, 5, 9, 15, 16, 17, 18, 19, then 27, 29, 35, 36, 47, 50, 58, and 63. And then the colleague Nikhil will take over the other batch of 16. And then tomorrow you have Kailash Vasudev and Krishnan Venugopal for 2 batches of 16 each. So that is how we cover the 64 important judgments of the leading judgments of Supreme Court. So these 16 I have divided into almost like 3 broad bunches. So first I'll deal with 2, 5, 15, 17, and 36. That is Menka Gandhi, A.R. Antule, Rupa Ashok Hura, P. Ramchandra Rao, and Skora, because they fall into a single pattern of structuring, and that is how we go about it. And then there are some of them we list to other, and then we join them, and then there are some independent judgments. Now let's go to Menka Gandhi straight. That is a judgment number 2 in the leading cases. So the procedure is the way I am approaching is I'll give you a slight bit of facts, because everybody should know what are the facts in the case. What led to the judgment. Then there's always, because these are leading judgments and most of them are constitutional bench judgments. So there are always a background. So there were some judgments which are already existing, which virtually led to these judgments. So the most important part of leading judgments are there are judgments which are considered in these judgments, and then these judgments have been considered in subsequent judgments. So when you attempt the examination, you will have to know both of them. So the leading judgment is somewhere in the middle, because it has opened the vistas for the new approach of the courts, and then the court has continued. So the head of the list is Menka Gandhi, which is 1978 to SCR 621. One of the most important fact I can tell you is that this is the judgment which has been followed in more than 200 judgments of Supreme Court. And that makes it the leading judgment. Now let's go to understand the facts of it. The petitioner here was issued a passport on 1st of June 76 under the Passport Act of 67. And on 4th of July 77, she received a letter from the regional passport officer that it was decided by the government of India to impound her passport under section 10(3)(c) of the Act, of the Passport Act. And the petitioner was required to surrender her passport within 7 days. The petitioner requested the government and then on 6/7/77, the government of India, without giving us reasons, made an order saying that her passport is impounded in the interest of general public. So writ petitions were filed challenging the impounding of the passport and declining to give the reasons. Now, just to have a background, in 1950, the A.K. Gopalan's case, which is A.K. Gopalan, is 1950 SCR page 88, the Supreme Court had interpreted liberty very narrowly. And it virtually held that Article 14, 19, and 21, there are individual verticals. So you can't test a particular action on the basis of all the 3 integrated read together. So either you go on 14, or you go on 19, or you go on 21. So you can't just have a approach where all these 3 are integrated. Now and then in Kharaksin's minority view, in fact, they expanded the definitions of personal liberty. On the second end, in A.K. Kripak, which is 64-1 SCR 332, which is 67, it was held that natural justice is mandatory before taking an administrative action. So Menka Gandhi, the issue was twofold. One was whether the action was in violation of natural justice, and secondly, whether the right to move outside India was a fundamental right, and whether then 14, 19, and 21 can be read together. So Maneka Gandhi upheld that the personal liberty under Article 21 is in its ambit included right to free movement of travel abroad. So this was expansion for the first time of Article 21, and further held that the procedures contemplated must also answer reasonable, just, and fair. Now, these are the most important part, that the procedure should be reasonable, just, and fair. It is not merely that the substantive law should be reasonable, just, and fair, because if in the background there was Keshavanand Bharti, which is 73 Supreme Court, where they held that the constitution provisions, the provisions should be the statute it should be on the basis of basic structure. Now here they came up for the administrative action. They came out with reasonable, just, and fairness on the procedure, and that it should not be arbitrary and fanciful. So then they held that this 14, 19, and 21 should be read together. They can't be read as individuals. And in that manner, A.K. Gopalan was overruled. So they held that Section 10(3)(c) of the Passport Act was void and violative of Article 14 of the Constitution because it conferred vague and undefined power to the Passport Authority. And since it did not provide the opportunity to the aggrieved party to be heard, it was also violative of 14, since it did not affirm the procedure as mentioned by the court. But the court refrained from passing a formal order in the matter and ruled that the Passport Authority will look into the matter on their own. Then we go down to the next judgment, which is Antule's case. Now, in Antule case, the appellant was the Chief Minister of Maharashtra, facing charges under various sections of Indian Penal Code and Criminal Law Amendment Act of 1952. So a special judge was appointed. A special judge issued processes against the appellant based on the complaint filed by a political person, a member of the political party. The appellant challenged the processes, arguing the lack of proper notification under the Criminal Law Amendment Act of 1952. So the government then specified that the government notified a special judge to try the specified offences, leading to the appellant's discharge. Now, complaint discharge was allowed by the Supreme Court, which set aside the order emphasizing the need for an expeditious trial. The Supreme Court then withdrew the cases to the special judge and transferred to it a High Court, and now they transferred it from the special court to the High Court for expeditious disposal, and the directed a sitting judge to go on with the matter. The appellant filed various petitions challenging the jurisdiction of the special judge and framing the charges. The Supreme Court, while granting the leave, stayed the proceedings and tagged it with the appeal. Now, it was a matter that was argued that the High Court violated the Criminal Law Amendment Act of 52, which mandated trial by the special judge, and the court held that the transfer order was unauthorized by law and only Parliament could confer jurisdiction to appeal, to alter the rights of appeal. Now, in the Antule's judgment, the court held that the power to create or enlarge the jurisdiction lies solely with the legislature. Want of jurisdiction can be corrected only by a superior court, not through the collateral attack of an inferior court. Therefore, the Supreme Court rectified its earlier order. Now, that's the most important part in Antule. They rectified their own earlier order, setting aside the proceedings and the subsequent transfer, and directed the trial to proceed according to the Criminal Law Amendment Act of 1952. The court determined that the directions issued in 1984 transferring the case of the special judge to the High Court was void because they lacked the legal authority. The transfer deprived the appellant the right to have a case tried by the special judge as mandated by the Criminal Law Act of 1952. Now, the court acknowledged, now this is the enlargement. This is the initial stages of development of the jurisdiction, the power under Article 142. So the court acknowledged that it was within its power to correct its own error, particularly when they resulted in deprivation of the fundamental rights, such as the right to life and liberty. Therefore, it held that the directions were erroneous and should be rectified to ensure justice. Now, this is particularly the enlargement of Article 142 And then it's also said that the 7 judges, the 7 judges were divided into 4:3, declaring the 1984 judgment to be unjust, illegal, and unconstitutional under Article 21 of the Constitution, as it restricted the right for the appellate remedy. So you can see the common thread moving between Menka Gandhi and then going to Antule's case. Now from this we go to Rupa Ashok Hura, which is item number 15. And this Rupa Hura, it established the concept of a curative petition. So you can still see the enlargement of the jurisdictions. So the background of this case is that prior to Rupa Ashok Hura case, the Supreme Court has recognized the inherent power of the character. That is where we had talked about the Antules case. And then also in MS Elawat and Harbans Singh versus State of Uttar Pradesh and Supreme Court Bar Association judgment, the court had willingness to correct. It has also come out with the willingness to correct its orders under Article 142 of the Constitution. Now, ultimately, the whole idea with the court is to do complete justice between the parties. So wherever the court feel that something has gone wrong or something is not only with respect to there are three facets, whether it is statute or it is administrative action or it is court's own judgments. The courts have always come out with the structure to resolve the issue and also to come out with jurisdiction which can help to do ultimate justice between the parties. So this, not all those cases, earlier cases were of 32 and highlighted that 32 in 32 petitions the court has done it. But there was an earlier existing judgment of Mirajkar. That was a 9 judges judgment where they have held that no writ petition could lie against the judgment of any court. So virtually Antule case was referred on one side, and then there were the other cases of Elawat and all this sort. So they all jumbled up and they came up, which came up with a view that how can you come up as against a writ petition against the judgment of the Supreme Court itself. So therefore they carved out this whole idea of a curative petition. Now, if you see the facts of the Hura case is very interesting. It was basically a matrimonial dispute between the petitioner and Rupa Hura and Ashok Hura. So they got married, and then both the parties had jointly filed an application for divorce. And 85, Ashok filed an application for divorce independently, seeking a decree. Now these matters, then they withdrew the consent of the decree. So the court, when the matter reached the Supreme Court, the 2 judges they granted seeking divorce was granted by 2 judges bench. Then the Supreme Court judgment in Ashok especially, they granted a payment of 10 lakh rupees to Rupa. In the review petition was dismissed. However, the 3 judges bench dismissed review petition, referred the bench to a constitutional bench for framing a constitutional issue. So the constitutional issue which came up was whether an aggrieved petition can seek relief against a final Supreme Court judgment and the dismissal of the review petition earlier, Article 32 or otherwise. So this was again because the feeling was, on the underground feeling was, if the judgment of a Supreme Court is unreasonable, unjust and proper. So you can see the common thread running after Menka Gandhi. So whether it is administrative law or whether it is everything, the statute or it is the judgment. So the petitioner in this case was argued that the finality of the judgment overriding the principle of natural justice and fundamental rights. The Attorney General and amicus curiae argued in favor of the relief and giving that miscarriage of justice, if it takes place, then the court should remedify it. So finally, it was they held that let us create a curative jurisdiction. That is how the curative jurisdiction came into place. So ultimately what happened was they balanced the finality of the judgment and ensuring justice. The finality of the judgment was balanced with ensuring justice. The role of curative petition preventing miscarriage of justice and need to clear guidelines to prevent misuse of curative petition. That was also laid down. So these things are important for every one of you, because ultimately you'll have to deal with them and put them down into your answers when the question comes. Then the next in the line, which restrained it, came the judgment of Ramchandra Rao, which is state of Karnataka, which is item number 17 in the leading cases, 2002-3 SCR, page 60. Now, inspired by the judgments of Menka Gandhi, Menka Gandhi 78, Husainara Khatun is 80, the procedure should be reasonable, just and proper, which included speedy trials. The Supreme Court in Common Cause 1, there are 4 cases. Common Cause 1 came in 1996. Common Cause 2 came in again in 1996. Then Rajdev Sharma came in 1998 and Rajdev Sharma 2 came in 1999. And as a cumulative effect, they fixed 2 years from the date of framing of charges as the period for commencement of trial, failing which the accused was entitled to an acquittal. Now, this is what came up as a judge-made law. Now, in this particular case, the accused was facing for corruption charges, were acquitted by special courts in terms of direction of the Supreme Court judgment, and there were failure of commencement of trial despite of 2 years. The state, this particular case related to economic offences. So the appeal of the state went in appeal to the High Court. The High Court allowed the appeal without even issuing a notice to the accused. To the Supreme Court, the question of consideration arose whether the earlier judgment of Supreme Court would apply to prosecution under Prevention of Corruption Act 1988 and other economic offences. The case was therefore referred to a constitutional bench. Now, during the hearing of the constitutional bench was the opinion that the direction of the Supreme Court comprising of 2 and 3 judges, that was when I referred to those, the judgments in Common Cause and Rajdev Sharma, ran counter to the constitutional bench in Antule's case, because Antule case they already corrected the jurisdiction. So whether these two are in contradiction with each other. So they of putting out the outer limit in a trial. Now there is no outer limit in a trial which can say that within 2 years if you don't commence the trial, then you will be acquitted. So this was the issue which came before the 5 judges. Then, and the real issue was that whether in the zeal to protect the right to speedy trial, can the court devise a bar of limitation, though the legislation by the statute has not chosen to do so. And the Supreme Court came out formulated a unanimous judgment by Justice Lahoti, and it says that it was neither advisable nor feasible nor judicially permissible to draw, prescribe an outer limit for conclusion of all criminal proceedings. The time limit to the bar or limitation prescribed in the several directions made in the Supreme Court could not have been so prescribed or drawn and are not good law. So they virtually overruled all the judgments of the Supreme Court which provided for a bar, for providing for a time limitation to start the trial. And the criminal courts were not obliged, this is what it held, to terminate the criminal proceedings merely on account of lapse of time as prescribed in the direction. And then it further held that prescribing periods of limitation at the end of which the trial could be obliged to terminate the proceedings and necessarily acquit and discharge the accused, and further making such direction applicable to all the cases in the present and for future amounts to legislation. Now, this is a very important lines and you must mark it out, which cannot be done by the judicial directives and within the arena of judicial lawmaking power available to the constitution courts. However, liberally, Article 32 or Article 21, 32, 141 and 142. So these are the liberties basically in Article 21, because if you see, as I said earlier, after Menka Gandhi, the expansion of Article 21 was increasing. And on the other side, the power under 142 was also increasing. Ultimately, how do you justify it? So the back of it was Article 142. So they say, in spite of all this expansion, you can't do this. So the courts can declare the law, they can interpret the law, they can remove obvious, now these are very, very important, which you should understand. They can remove obvious lacuna and fill the gaps, but they cannot entrench upon the field of legislation properly meant for the legislature. And the judiciary may not, like legislation, enact the provisions akin to or what are provided under the Criminal Procedure Code. So this covers this judgment, and then we go down to the Scora judgment, because that is the fifth in the line of that same series. So in the Scora, which is 2015-13 SCR page 1, the real issue, which is also known as the fourth judge's case, the challenge was to the Constitution 99th Amendment Act of 2014. So the 99th Amendment Act provided for creation of a National Judicial Appointment Commission, provide for a National Commission Act 1914. Now the NJAC, which is called the NJAC, proposed to replace the existing collegium system for appointing higher judicial members, that the judges of the High Court and Supreme Court, with a National Judicial Appointment Committee, intending to increase the transparency and accountability. Now the issue is the transparency and accountability is on both ends, whether it is Supreme Court or whether it is the government. That there's no lack of transparency. Everybody wants to be transparent and everybody wants to be accountable. But the more important is that we must, if we look into the root of the collegium system, which is very, very important and is seriously something has to be understood. So the collegium system traces its root to the case of Sakal Chand Himmat Lal Seth, which is 78-1 SCR 423, where the Supreme Court emphasized the consultation of the Chief Justice of India in judicial transfer. This was a case where Justice Himmat Lal Seth was transferred from Gujarat High Court to Madras High Court during the period of emergency, and without the consultation of the Chief Justice. So this is where it really started. So this should have been the first judge's case, but it is not known as it. The first judge's case is what is called the SP Gupta versus Union of India, which is 1982 SCR 365, which relate to the transfer of 3 judges from different high courts, chief justices, and also upon confirmation of ad hoc judges in the Delhi High Court. This what became the SP Gupta's case, where they said no, you can't do this, and that you can. But the real issue which came out was that the consultation with the Chief Justice is not a mere perfunctory. It can't be an eye wash. It is just not. It is so. Basically, it's like the consultation you have with a medical doctor. So you have to give him the facts, and he will give you an opinion, and his opinion is binding upon you. Now this is where the SP Gupta case came up as the first. Then this came up. Then in 1993 came the second judge's case, where the collegium system was established. And they said that the 5 senior judges will be a collegium consisting for appointment of judges of Supreme Court, and 3 judges collegium for the purpose of approving the appointment of all the judges in the high courts. So this is where they established now this is basically, again, one can say that this is the legislation by the courts. But again, because the field was wide open. And then the court really based its opinion on the basis of the basic structure. And here the basic structure was independence of judiciary. So they firmly held that independence of judiciary, which again in Indira Gandhi's case, where the constitutional amendment was struck down on the basis of that no appeal shall lie to the no appeal, nobody can challenge the validity of the elections. So that was struck down. So the judicial independence was always held to be part of the basic structure. Now this second judge's case was again reaffirmed in the third judge's case, which is the special reference 1 of 1998, where a reference was made by the President of India, and they made it very clear that the collegium system is a part of the basic structure of the independence of judiciary. In that light came the 4 judges case, which is the NJC case. So the Supreme Court again with the 7 judges, 6:1, Justice Chalmeshwar went for a dissent, and they held very clearly that by majority 4:1. So they struck down the 99th Constitution Amendment, and consequently the NJC Act was held to be unconstitutional and void. The majority held that the involvement of the executive in the judicial appointment violated the principle of separation of power. Now this is a very remarkable, because a lot of people have criticized this judgment by saying the appointment is always an executive function. But they say no, here it is the appointment of, you are talking of appointment of judges. So this is again, we know who are the better people to be appointed as at least judges of Supreme Court and High Court. And that is a part of the independence of judiciary, which is a part of basic structure of the Constitution. So this is how came the NJSC judgment. And then we go to the next judgment, which is Shreya Singhal, which is number 35 in your list. The Shreya Singhal is a judgment which is 2015 3 SCR 963. This is a judgment which is a landmark case concerning the constitutional validity of section 66A of the Information or Technology Act 2000. Now the issue was that whether section 66A introduced an amendment in IT Act of 2000 in 2008, allowing authorities to detain and imprison individuals for allegedly making offensive and intimidating internet posts. So the facts of this basically case is that the Mumbai police arrested two girls, Shaheen Dada and Reno Srinivasan, in 2012 for posting comments on the Facebook criticizing the Bandh called after Shiv Sena leader Bal Thackeray's death. So arrest was made under section 66A of the IT Act and punishable people for offensive messages on the internet. So the arrest led to the public outrage and protest across the country. The Shreya Singhal, along with others, challenged the validity of section 66A. Now then the court held that the section 66A of the Information Technology Act was unconstitutional, and it was struck down as being violative of Article 19(1)A, and that it was not saved by Article 19(1)(2) of the Constitution. And the reasoning was very clear. The reasoning of the court was that section 66A was vague and did not clearly define what constituted an offense. And the law was open to subjective interpretation, not objective interpretation. Because one of the basic issues of criminal law is that it should be objectively definable. You see, the facts will have to be established, and you can't presume by law a criminality. So here it was a case virtually where you are defining that if you make an offensive statement, now this offensive statement itself is a subjective analysis. So the court was very clear that the law can't be open to subjective interpretation, leading to arbitrary arrest and infringements of freedom of speech and expression. And then it upheld the importance of free speech and expressions and guaranteed by the Indian constitutions. So the significance of the judgment is basically that it upholds the fundamental rights of freedom of speech and expression online. And it prevents arbitrary arrest or prosecution and expressions of opinion online. So this is what you can see, the shift from our regular books and all situation to an online situation where the whole world was moving to the online situation. And then this judgment struck down 66A of the technology, protecting the citizens' right to express opinion online without fear of arbitrary arrest and prosecutions. So this now we take to Navtej Singh Johar, which is 47. Now, Navtej Singh Johar, which is 2018 7 SCR 2379. Now, all these cases, if you see, they are all basing their fundamental reasoning on Maneka Gandhi and Keshavan Bharti. So the Navtej Singh Johar virtually dealt with the constitutional validity of section 377 of the Indian Penal Code, which criminalized consensual sex conduct between adults, particularly same-sex relationships. The petitioner argued that section 377 violated the fundamental right guaranteed under 14, 15, 19 and 21 of the Indian Constitution. So now the background is that the section 377 of the Indian Penal Code criminalizes consensual sex intercourse between persons of the same sex, terming it as unnatural offense. In 2009, NAS Foundation challenged the constitutional section 377 of the Indian Penal Code in Delhi High Court. And in 2013, the Supreme Court in Suresh Kumar Kaushal was in Nas Foundation overruled the Delhi High Court decision and upheld the Constitution of Article 377. Navtej Singh Johar filed a writ petition challenging the decision of the Supreme Court in Suresh Kumar Kaushal and Constitution of Article 377. The matter was referred to a larger bench. So the real issue was that whether Section 377 of IPC violated the fundamental rights to expression under 19(1)(a) by criminalizing the gender expression of persons belonging to also to LGBTQI plus community. Now, was the rationale of the Supreme Court judgment in Suresh Kaushal case was sound in its understanding the morality as a social morality. Now, here they came out with the concept of the social morality. And then whether Section 377 violated Article 14 and 15, allowing discrimination on the basis of sex orientation and gender identity. And whether Section 377 violated the right of autonomy and dignity under Article 21 by penalizing private consensual acts between the same-sex persons. Now, this was argued before the court, and the court finally held unanimously. It overruled the judgment of Kaushal, and it held that Section 377 violated fundamental rights under Article 14, 19, and 21 of the Constitution. The same thread that 1492 is like now we call it a golden triangle. So these are the three judgments which are with three articles of the Constitution which work together. So the court recognized that sexual orientation was an inherent part of the individual's identity, dignity, and autonomy. And that declared Section 377 as unconstitutional to the extent that it criminalized consensual sex conduct between adults, whether same-sex or otherwise. And then the court clarified that the consent should be free, voluntary, and devoid of any duress or coercion. Now, the reasoning which the court really found was that it was discriminatory and arbitrary, as it targeted consensual relationship between adults in private, and emphasized on the interrelationship between privacy, autonomy, and consensual orientation, citing the Nalsa and Puttaswamy's judgment. So every case, if you see it at all, they become leading cases because there is a basis for what has been going on in the society and what has been decided earlier by the courts itself. Now, the significance of this judgment is basically decriminalize the consensual sex relationship between adults irrespective of the gender orientation. Now, that we go down to the next judgment is Joseph Shrine, which is item number 50, 2018 11 SCR 3765. Now, the court here was dealing with an archaic and with another section of the Indian Penal Code, which is Section 497, as violating of fundamental rights, particularly with regard to gender equality, autonomy, dignity, and privacy within marriage. So there were earlier judgments of Yusuf Abdul Aziz, that is 1954 SCR 930, where the constitutionality of Section 497 was challenged on the ground of violating of Article
He got disconnected. He's just coming back.
For the interruption, the light went off. Am I audible now? Hello?
Yes, sir. You're okay. Your image is a
Okay,
little
so we
blurred,
were
but
dealing with the Joseph Shine case. So the background was the Yusuf Abdul Aziz judgment. Then Saumitra's Vishnu versus Union of India, that was 1985 Supreme Court. And V. Revti, that was 1988 Supreme Court. And another was the W. Kalani cases. So there are the four cases which were on the background of this judgment when it was came out. So Joseph Shine was a close friend of Kerala. In Kerala, committed suicide after a female co-worker made a malicious rape charges against him. And Joseph Shine, a hotelier, then Joseph Shine close friend in Kerala. So Joseph Shine hotelier, he filed a writ petition under 32 challenging the validity of section 497 of the Indian Penal Code. Led with 490. Hello. So the Supreme Court held that unanimously struck down section 497 IPC and section 198 of CRPC, declaring them to be unconstitutional. The court held that section 497 was archaic, arbitrary, and infringed upon a woman's autonomy, dignity, and privacy, and that adultery was decriminalized, and the court recommended treating it as a ground of a civil wrong rather than a criminal offense. So that is the important, the significance of judgment marked the significant shift in understanding of marital relationship of individuals' autonomy. And then it reaffirmed the principle of gender equality and recognized the rights of women within the marriage. And the decision also highlighted the importance of sexual autonomy, dignity, and privacy as a fundamental right. So this is again expansion of Article 21 by the Supreme Court. Then the next in this series is Pradeep Kumar Vishwas versus Indian. This is item number 16, which was the Indian Institute of Chemical Biology. Now, this should not hold us long. This is basically a judgment where they held that the CSIR is a part of Article is a covered under other authorities of Article 12 of the Constitution. Now, the background of this case was basically that in 1975 there was an ONGC judgment. There's a judgment of Sukhdev Singh, where they held that ONGC was a statutory corporation and was covered under Article 12 of the Constitution. Now, then subsequently they continued to interpret it by covering International Airport Authority and other. But then there was an earlier judgment on the same date. That is very interesting. This 1975 3 SCR. There are two judgments which are back to back, same 5 judges, and one of them held that it was not an Article 12 authority. A society was not an Article 12 authority, and statutory corporations and other authorities were covered under Article 12. That was Sarabjit Tiwari's case. So there was a conflict, and then Ajay Hasia judgment took up, and they said that society where it is a government's overall control was there. Those were where it can be held to be it has to be covered under Article 12. So there was a conflict of opinion between Sarabjit Tiwari's case and the ONGC case. So in this, Pradeep Kumar Vishwas, they said that institute, and in fact, this Sarabjit Tiwari was a matter which related to CSIR. So the 7 judges, they overruled Sarabjit Tiwari, and they held that CSIR was covered under Article 12 of the Constitution, and then therefore a writ petition can lie against CSIR. So this takes us to this, and then next we take up is the special reference 1 of 2012, which is item 27 in your list. Now, this judgment, this special court reference is 2012 9 SCR 311. Now, here a reference was made by the President of India referring 8 questions relating to award of 2G spectrum case. Now, judgment relating 2G has already come by the Supreme Court, already there. So the court rejected the contention that any reference was maintainable under Article 143 of the Constitution, as it seeks to overturn the judgments delivered by the court. And here they relied on an earlier judgment of the federal court, where there are only few cases where the reference made by the President of India has been returned back by the Supreme Court, saying that that this is not an answerable question. So this is again, here they held virtually that you can't seek a reference in a matter where the judgment would, when the opinion would virtually lead to overturning the judgment of the delivered by the court. And then the court opined that it could answer the reference to the extent it does not overrule the judgment. So out of the 8 questions, they answered 5 of them. So the court opined that, and then those were there, they held that under Article 39B, uses of broad term and limiting the meaning of such provisions to auction only would be violating the constitutional framework. The 39B is basically a part of the directive principle of state policy, where it is held that the material resources of the community should be so distributed as to subserve the common good. Now, this is again 9 judges' judgment. Now they are dealing with this. So maybe the whole issue will be is already being reconsidered. But the importance of this judgment is that it said that the natural resources allocation highlighted should be given by already in that 2G case that has to be there. Then the primary precedent's reference aims to seek advisory jurisdiction to clarify legal and constitutional parameter, therefore preventing future controversies. Then Article 39B mandates the distribution of resources for the common good and emphasizes that the government policy must prioritize the welfare of the citizens. And while policy formulations falls within the purview of legislature or executive judicial review, is limited to ensuring compliance with the statutory law and constitution. The most important part of this was that the auctioning, it recognized the method of the resource disposal. But that was not the only sole constitutional approach. So there can be other ways also. So this is what is the TMA 5 Foundation and PA Inamdar case. Now, they were the 2 judgments which were dealing with 18 and 19. They dealt with the educational institutions, the rights of minority institutions to regulate themselves, and also basically issue came about the fees structure. The real issue was minority unaided institutions, whether their fees structures can be regulated. So TMA Pi came earlier, that was 2002-3 supplement SCR, and then came up Inamdar, which was 2005. And then in Inamdar, they virtually held that that the Supreme Court that the court interpreted Article 13(1) to include religious and linguistic minorities, which the state being a unit consideration of the minority status, and that professional education was considered within the ambit of Article 31, granting minority institution right to establish the educational institution of the choice. And then the most important part is that the minority institution retained autonomy over admission process, ensuring transparency and merit-based selection. Now, the judgment has a far-reaching implications for admission policies in private unaided education institutions and the protections of minority right under the Constitution. Then, and I am almost at the end of it, Indore Development Authority was a matter relating to land acquisition law where it dealt with the right of fair compensation. That is item number 63. So enactment of the right to fair compensation, transparency in land acquisition and rehabilitation of resettlement act of 2013, replacing the archaic acquisition of land acquisition act of 1894. So in this, basically section 24 of the 2013 act was controversial, which came into it. The real issue was interpretation of section 24 of the right of fair compensation and of the 2013 act. Now the issue was that whether compensation deposited in the government treasury amount to payment to the landowners. Now this is the core issue which was to be decided. So that 5 judges constitutional bench decided and upheld the earlier judgment of Indore Development and held that the proceedings under section 24 do not lapse if the compensation is deposited in the treasury. So virtually they held that it is not that the money has to be given to the landowner, but even if it is deposited in the treasury, that amounts to payment of the compensation. So this is the one, and then we go down to Novartis AG. So Novartis was again a case of patent law, and this item number 29 in our list. So Novartis, in fact, was a company which tried to which applied for intellectual patent for a product which was generic in nature, and it was refused. The registration was refused, and then the Supreme Court upheld the refusal as to be correct. So just let me please. So the real issue in Novartis was of what they call as the evergreen. It prevents the evergreen of patent products by introducing minor changes. Evergreening refers to extending the life of a patent by making minor modification of the original product, and it ensures the availability of life. So this is where the real issue came up. Well, the decision was that why that makes it important is that it upholds section 3D of the Indian Patents Act, and section 3D of prohibit the grant of patent for new forms of known substances unless it demonstrates significance, enhanced therapeutic efficiency. And then finally, the Shanti conductors is the last case, which lays down the review, the conditions in which a review can be granted. So it's basically an interpretation of section 47 of the Limitation Act. So I've taken 4 minutes more. Thank you very much. Over to Nikhil.
Thank you, sir. I just hope I can also finish as efficiently as you did. Am I audible? Fine. So I will also try. I have got also, as Mr. Gupta pointed out, 16 allotted to me. You can just quickly note them down. I'm doing serial number 4, 10, 11, 12, 13, 14, 25, 26, 31, 37, 39, 41, 42, 46, 54, and 60. I have tried to bunch them up thematically so that will make it a little quicker and have some common theme or idea in what we're to discuss. So the first lot I've taken to bunch up together as a topic are D.K. Basu which is serial number 11, Vishaka, which is serial number 13, Shakti Vahini, which is 46, and Ashwini Kumar, which is 54. So reason why I've chosen to bunch these together, because essentially these are cases where the court has dealt with situations and what we call generally judicial legislation. It's not necessarily the correct phrase, but these 4 cases are normally discussed in that context. So I'll just deal with each one of them, and some of them are also linked to the judgment in Ramchandra Rao, which Mr. Gupta referred to in his lecture. DK Basu is the first in point in time, 1996. It arose from a letter petitions. In fact, the court received 2 letters, one from the Legal Aid Services Committee in West Bengal, and the other one was relating to a custodial death in Aligarh. The court decided to take up these issues, and considering it to be an all India issue, issued notices to state governments as well as the Law Commission. Now, the judgment is important because it discusses 2 issues. One is the steps to be taken to prevent custodial torture and deaths. And secondly, whether monetary compensation should be awarded if there is an established infringement of a fundamental right guaranteed under 21 and 22, Article 21 and 22. So the court holds that custodial violence is against the rule of law, and custodial torture is a violation of human dignity. And what flows from Article 21 is a guarantee, because there is a right to live with human dignity. What flows from Article 21 is that there is a guarantee against torture and assault by the state as well as its functionaries. So after discussing and laying down these principles, the court also holds that there is no defense of sovereign immunity. If there is a tortious act by a public servant, there is no defense of sovereign immunity, and an officer could be held liable. The judgment is actually equally famous for the directions that are issued at the end of the judgment, giving fairly detailed guidelines as to the safeguards for the accused at the time of arrest. The court has held that if a police officer violates these guidelines, it would render the police officials liable either for departmental action and even contempt of court. And the court has clarified that these directions or requirements are in addition to the constitutional and statutory safeguards that already exist. So they are intended to supplement, not supplant, the existing legal regime. These directions were directed to be forwarded to the DGPs of respective state governments, the home secretaries, so that they could be circulated to the various police stations and disseminated for the information of all concerned. The court also held that courts must give compensatory relief in case of a breach of public duty, and there's a right to be indemnified. The next case in sequence in this regard is Vishaka, which is also equally well known. Vishaka was a case where there was a instance of a gang rape of a social worker in Rajasthan, and a petition was brought as a class action by social activists and NGOs to seek a declaration for realization of gender equality and to prevent sexual harassment at the workplace, and sought enforcement of rights under Articles 14, 19, and 21 of the Constitution. So the court held, and for the first time, that sexual harassment is a violation of fundamental rights and the right to gender equality, and which is clearly covered by Article 14, 15, 21, and also 19(1)(g). The primary responsibility for ensuring safety and dignity is through legislation and on the executive, but in instances where a situation is brought before the court in a petition under Article 32 and there is no effective redressal mechanism, then the court can step in and provide a mechanism to redress such legal injury and such grievances. The court referred extensively to international conventions, and some of which had been ratified by the government of India, and issued detailed guidelines which were to be treated as law declared under Article 141 and to be treated as binding to deal with instances of sexual harassment at the workplace, and the court clarifies that these guidelines are to remain in place till any suitable legislation is made We do know, of course, subsequently that there is a legislation, but till the legislation came about, the Vishaka guidelines, as they are known, that is what held the field, and to deal with and govern cases of sexual harassment. It set up a mechanism how employers are to devise to have committees and deal with such complaints and allegations. The third in that sequence is Shakti Vahini. Shakti Vahini was a case where a petition was filed to seek preventive steps to combat honor crimes and to deal with the issues that, as we commonly they called in before, Khap Panchayats and situations like that. The court also deals with the fact that where you have two consenting adults, it is not necessary for the community or the consent of the family in such situations if there are two consenting adults entering into wedlock. And the choice of a life partner is something that is a manifestation of choice that flows from Article 19 and 21. Choice is an inextricable part of the right of dignity and therefore traceable to Article 21. And any violation of this right is a constitutional violation. Equally, the court held that in such situations, no assembly, no self-appointed body has the right to take the law into their own hands and to try and police or monitor such relationships. The court recommended that a law be framed to cover such instances of honor killing. But in the meanwhile, it gave a slew of directions, preventive, remedial, as well as punitive, which the judgment deals with. Some of the directions that they gave were like identification of districts where such incidents are prevalent, to issue advisories and to educate people, to have meetings to create awareness, and if necessary, where a situation warrants, there should be an FIR can be lodged against to protect the couple concerned and to ensure their safety. These judgments, finally, the discussion culminates in the judgment of Dr. Ashwini Kumar in 2019. Now, Dr. Ashwini Kumar, as you know, former member of former law minister, senior advocate, he filed a petition in the Supreme Court seeking a direction that there should be a comprehensive legislation on custodial torture, consistent with Article 21. In the course of this judgment, the court has extensively reviewed the earlier case law and discussed the theory of separation of powers. It discusses the respective roles of the executive and the legislature, and holds that the judiciary is independent and while exercising its power of judicial review, will not encroach upon fields otherwise reserved for the legislature or the executive. And the phrase used by the court is, it will not direct, advise, or sermonize to the other organs of the state. The court refers to the judgment in Ramchandra Rao, which Mr. Gupta has already pointed out, and notices that in the exercise of the power of judicial review, what is permissible is to interpret, to remove obvious lacuna, but you cannot entrench upon a field of legislation. And in that context, the court then explains these earlier judgments that I have just referred to, D.K. Basu, Vishaka, some of the other judgments in Kalpana Mehta, to show that the instances in which the court passed guidelines or gave directions were cases, two essential features. One, that they were egregious violation of human rights, and B, there was no existing legislation or legal regime governing the field. There was an obvious vacuum in the law, and it is only in cases where there was a vacuum in the law that the court stepped in and passed certain directions. In fact, in all the cases, as you have seen, the court has clarified that either those directions are interim, in the sense that till a full-fledged legislation is passed, or alternatively, these are meant to supplement and not supplant the existing legal regime that may be holding the field. These are the four that I wanted to cover on this aspect, on the scope and extent of judicial review, and within the context of whether in a given fact situation the court has, if I may say so, gone into the field of judicial legislation. So ultimately, in fact, in Ashwani Kumar, the court declines to pass any direction and says that directions can only be issued if it has to improve an existing legal regime, but we cannot direct Parliament to enact a law in a certain manner. And therefore, in that case, no relief was given to Dr. Ashwani Kumar in his petition. The next two cases that I want to deal with, which I again try to categorize as one similar theme, are the two cases with the interface of constitutional law and personal laws. One is Shaira Banu, which is serial 42, and the other is Geeta Hariharan, which is serial number 14. Now, Shaira Banu, as you all know, is the well-known case dealing with the validity of triple talaq. But Shaira Banu deals with two important questions, not only whether the question of triple talaq and whether triple talaq is an essential religious practice that is guaranteed under Article 25 of the Constitution, but deals with a very important facet of Article 14, namely manifest arbitrariness. I'll come back to that, but these are the two central issues which the judgment in Shaira Banu eventually decides. Now, you must remember that Shaira Banu is a judgment of a majority of 3:2. The majority obviously holding that triple talaq is unconstitutional. Even on the question of Article 14 and manifest arbitrariness, it is essentially the leading judgment of Justice Nariman, to which Justice Lalit concurs, and Justice Kurian Joseph states that on all other questions, including the question relating to Article 14, although he doesn't give any separate reasons, he concurs with the judgment of Justice Nariman. So by majority of 3:2, this question of Article 14 and manifest arbitrariness also becomes the majority view. Now, on the first aspect of the validity of triple talaq, after extensively quoting and referring to religious texts and writings and well-known authors on the subject, the court deals with what is the essential religious practice. Because as you are aware, to get the benefit or to get protection under Article 25, for the right under Article 25, what is to be shown is that the religious practice or belief or doctrine that you are seeking protection of is essential. It is a core or it is fundamental to that religion. If the practice to which is in challenge is not essential to that religion, then that protection under Article 25 will not be available. The court referred extensively to its earlier judgment in the Anand Margi's case, and from there culls out the principles that are necessary to determine whether a practice is an essential religious practice or not. So some of the tests that are available in the Anand Margi's case, which the court adopts, is that it is not confined, the guarantee under Article 25 is not confined to doctrines or beliefs, but also to rituals, observances, and ceremonies which are essential or integral. What constitutes integral or essential has to be determined with reference to doctrines, practices, tenets, and historical backgrounds. It's only those core beliefs upon which the religion is founded are those which are protected. Essential religious practices are those which are fundamental to be followed. If something is ancillary, it is not fundamental to the religion, it does not get the benefit of protection under Article 25. And the test to determine whether it is core or fundamental is that whether the nature of the religion will change with or without that practice. So is it so fundamental to that religion that the nature of the religion will change if that practice is allowed or disallowed? Those which are alterable, or those practices or beliefs that are alterable, are therefore not the core and not protected by Article 25. In the facts of the case, they found that though triple talaq is permitted, but on a reading of certain religious texts, it was also opined in those texts that it is considered to be sinful, and therefore the court found, and one of the important things that the court has observed in the course of the judgment, that merely because something is permitted doesn't necessarily mean that it is valid or lawful. And in that situation held that triple talaq is unconstitutional. The second facet, as I pointed out, of Shaira Banu, which is very important, is the aspect of manifest arbitrariness. Because an earlier view had been taken in McDowell's case that manifest arbitrariness cannot be a ground for setting aside for quashing or for questioning plenary legislation. Arbitrariness, as we've understood it, is always available to challenge executive action or even subordinate legislation. But where it comes to plenary legislation, parliamentary legislation or state legislation, can there be a challenge of validity on the ground that it is arbitrary? McDowell took a different view. Justice Nariman's judgment deals with that in detail and finds that McDowell actually did not correctly follow earlier precedents, and ultimately holds that that arbitrariness is also a ground to challenge, on which plenary legislation can also be challenged, quite apart from subordinate or executive action. The other case relating to personal laws is that of Geeta Hariharan, which is serial number 14. Now, Geeta Hariharan was a well-known author. She had made an application for some investments, for some RBI bonds in the name of her minor son, and stated that she would act as a guardian. The RBI insisted that only her husband could sign and that she could not sign. The reason for this approach was that because 6A of the Hindu Minority and Guardians Act says that the natural guardian will normally be the father, and after the father, it could be the mother. Now, the question was, how do you construe the word after? Does after mean only after the lifetime or any other meaning? The court held two important things. One is, what is of paramount interest is the interest of the child. And the best interest of child is what the court has to look at. It does not make a difference is whether it's the mother or the father. The primary focus has to be the best interest. Secondly, the court held that if the phrase after is construed to mean only after the lifetime, then that would render the clause unconstitutional. The court therefore reads down after in 6A and said after can only mean a situation where the father is wholly indifferent, or where there's a mutual understanding between husband and wife that the mother can be the natural guardian, or where the father may be physically unable, and certain instances like that. So the court read down the provisions of 6A and consequently granted relief and permitted Geeta Hariharan as the mother to act as the natural guardian and submit the application for those RBI bonds. So this is an important case for both reading down as well as saving the provision and upholding the principle of equality and gender equality. So these two judgments deal with that aspect. I will now go to two judgments which is in my list, which pertain to environmental aspects, which is serial number 10 and 41. 10 is Vellore and 41 is Common Cause. Vellore is 1996, and it's important for laying down the principles of sustainable development and polluter pays principle, which you would have seen subsequently has been followed in numerous cases. You must also find out those cases where it is followed and been applied later on. In Vellore, the situation was that there were a large number of tanneries near Vellore, which were discharging untreated effluent and causing a great deal of havoc because it was polluting the groundwater, it was affecting crops, it was affecting the lives of people living in the neighborhood. A public interest litigation was filed seeking action to be taken as far as these polluting units are concerned. In this context, the court held that while no doubt tanneries is an important industry and it contributes to foreign exchange, etc., but we have to move away from the traditional concept of development and now accept what is called sustainable development. That is balancing the ecology and development. It can't be just a one-way street. Along with the concept of what flows from the concept of sustainable development is also the precautionary principle and the polluter pays principle. Now, what do these two principles envisage? The precautionary principle in the judgment, the court has highlighted three broad aspects. One is environmental measures that you anticipate and prevent. That is, as the word suggests, precautionary. Secondly, where there are threats to serious damage to the environment, merely because there is a lack of scientific certainty, should not be used as a reason for postponing any measures to be taken. So if something is potentially hazardous, but one is not able to show with great deal of certainty what the scientific solution is, but if there is a grave threat or a hazard, that itself requires a precautionary approach. And thirdly, which is linked to the second question, that the onus of proving that a process or an industry is environmentally benign, that will lie on the developer, on the industrialist. So the project or what we nowadays call project proponent, the project proponent now will have to show that the process or industry that they are engaged in, that is the industry, their process or methods are environmentally safe. The third aspect of polluter pays, the expansion of the concept in the judgment is that it is not just that you pay the victims of the pollution, that is the persons who are affected, but you also have to pay a cost for restoration. That is remediation of the environment, remediation of the damaged environment, all that flows from the concept of sustainable development. And the court finds that these principles are derived from customary international law and are part now of our municipal law as well. In fact, you will probably be aware that these principles now are statutorily recognized in Section 20 of the NGT Act, because the NGT Act in Section 20 says that while deciding cases, the court will be guided by the precautionary principle and the polluter pays principle, etc. So there's a statutory recognition of what the court has held and subsequently followed in Vellore. In the facts of that case, the court also found that there is a provision in Section 3, subclause 3 of the Environment Protection Act, and they constitute an authority to deal with the instances of pollution in Vellore and to create a separate environment protection fund. The judgment in common cause dealt essentially with illegal mining. It's an important case because it deals with the concept of environment clearance in mining, and it expands the scope of environmental clearances for mining, not just for what is carried out in the mining or in the area of mining, of the mining operation area or the mining area, but outside the lease area as well. And certain important principles are laid down, like that the EC is mandatory. The EC will take precedence over the mining lease. It is not subordinate to the mining lease. And there is no concept of retrospective environmental clearance. The validity will only start of the environmental clearance will only start from the date of the actual environmental clearance. It also talks, this judgment also deals with intergenerational equity, which is in a sense linked to the whole concept of sustainable development. After these two cases, I will now deal with, there is a bunch of cases on criminal law which are also in my scheduled quota. First, I will go to Lalita Kumari, which is serial number 31. Now, Lalita Kumari was again a petition under Article 32, where it was a petition filed seeking directions for the protection of the petitioner's minor daughter. And the grievance was that despite going to the police station, no action was taken. They had to go to the superintendent of police. Then even thereafter, no action was taken. And initially, when the matter was heard by a two-judge bench, it was found that this practice is quite prevalent in various parts of the country, and it was referred to a larger bench. The court also found, before it came to the larger bench, that there were difference of opinion in various judgments of the court. So to resolve the conflict, the matter was referred to a constitution bench. The constitution bench holds, or the question that was before the constitution bench, that whether when there is a report of a cognizable offense, is it compulsory to register an FIR, or does the police have the power to first conduct a preliminary inquiry and then thereafter decide whether an FIR is to be registered or not? On a review of the CRPC, especially the scheme of the code, the court found that the legislative intent is to make registration compulsory in case of a cognizable offense. And the court refers to the placement of section 154 in the code and says 154 comes prior to 156, because only if there is information in 154, then will the investigation proceed thereafter under 156. Another argument was raised that to try and contend that why registration is not compulsory, a parallel was drawn from section 166 capital A of IPC. Now, 166 capital A of IPC is a punishment in case a public servant disobeys the law. And one of the subclauses says that if a police officer refuses to register an offense, register a case for certain defined sections, 376, 354, 354A, etc., he is liable. So the argument that was sought to be raised was, listen, it is only these category of cases where it is compulsory. In all other cases, there should be some leeway. The court rejects this contention and holds that the word used in section 154 is shall. And the first rule of interpretation is a literal rule of interpretation. If a literal rule of interpretation does not lead to any absurdity, then we will follow the literal rule of interpretation. And the literal rule of interpretation for 154 will be that the officer in charge shall register an FIR. There is also no reason to read in, because again, that was one of the contentions, whether the information has to be reasonable or credible. Those are all extraneous factors. One of the other arguments raised was that in many states, there is a practice of making what is known as an entry into the general diary. So an argument was sought to be raised that if they will make an entry in the general diary, then there will be a preliminary inquiry, and that may result in the culmination into an FIR. That argument is also rejected by the court, that merely based on that practice, you cannot derogate from the fact that registration is compulsory. An apprehension was expressed by some of the parties appearing in that case that if you make registration of an FIR compulsory, it will make arrest mandatory. The court holds that that doesn't necessarily follow, because an investigation under the aegis of the CRPC is an investigation in accordance with Article 21, because that is the procedure established by law, and therefore an investigation under Section 154 is in conformity with Article 21, and there cannot be any apprehension of a mandatory arrest. The court, however, lays down 4 exceptions to this rule of mandatory registration of FIR in a cognizable case. One is cases of medical negligence. where the court has held it should be referred to a medical board and then based on that view. Second, in matrimonial cases. Third, in corruption cases. And the fourth exception is where there's abnormal delay and laches. Now, as far as in these cases where some preliminary inquiry, especially in matrimonial cases, is concerned, the court in its concluding portion says that 7 days is reasonable time to have the preliminary inquiry. Subsequently, on a clarification or an application moved, I think it was by the Delhi police, the court in a subsequent order, though the order is passed in 2014, it is reported much later only in 2023 9 SCC 695. It clarified that this period of 7 days could be extended to 6 weeks. But subject to that clarification in the operative part of the judgment, the rest of the judgment remains untouched. After this, I'll quickly go through some of the other judgments of on criminal law. One is serial number 60, Shushila Agarwal, that is on anticipatory bail. Two questions were involved in that case, that whether because there were conflicting views and the matter was referred to a constitution bench. One was whether when a protection is granted under section 438 CRPC, should it be for a fixed period? And secondly, whether the life of an anticipatory bail ends at the time when the accused is summoned to court. The court extensively refers to the earlier constitution bench judgment in Gurbakh Singh Sibia. It reiterates that view and finally holds that in fact it overrules partly two judgments. It overrules the judgment in Siddharam Maitre, which said that the life of an order under 438 cannot be curtailed. It was held to be incorrect law. It also overruled Salahuddin Sheikh, which took the extreme view that the order of anticipatory bail has to be limited in time frame. And it was held that both these judgments are contrary to Sibia. So ultimately, the court found that a protection need not under 438 be limited in time, and in fact also held that the life of an order of anticipatory bail does not end normally at the time and stage when the accused is summoned or when charges are framed, but in fact can even continue till the end of the trial. The next case is Sriharan, which is serial number 37. That is again a case on the matter of sentencing. The question there was whether you can have what is the meaning of the word life imprisonment? Whether life imprisonment means rest of your life or rest of the convict's life, or can, as was held in the earlier judgment in Swami Shraddhanand, there can be a special category of cases where there can be a minimum sentence that is imposed. Here again, there is a split verdict, 3:2. The majority judgment is delivered by Justice Khalifullah, and the court found that holds two things. It holds that though for the purposes of, in terms of section 53, read with section 45 of the IPC, imprisonment only means imprisonment for the rest of the life of the convict. But there are rights that are provided for remission, commutation, reprieve, etc., which are always available as constitutional rights. And secondly, the court upheld the view in Swami Shraddhanand that you can have a special category of cases where instead of death, it can be substituted by a punishment for imprisonment for life or for a fixed period, and for that period, the benefit of remission will not be available. The last couple of cases that are left are, one is Selvi is an important case also on self-incrimination. It's the right under Article 20. So the question there was whether involuntary administration of narco analysis, polygraph, and brain electrical activation tests are violate the right of self-incrimination under Article 20. The court held that any compulsory administration of such tests violates the right of self-incrimination protected under Article 20, subclause 3. And of course, they said there can be a voluntary administration, but its admissibility will they cannot be admitted in evidence, but anything, any material collected pursuant to that would be admissible through Section 27 of the Evidence Act. The other two cases, which are generally on general principles of criminal law, one is serial number 4, Sharad Birdi Chand, and number 39, which is Mukesh. Sharad Birdi Chand is an important case on circumstantial evidence and discusses the principles of deciding a case based on circumstantial evidence. And it refers to the 5 golden tests or principles in Hanumat versus State of MP 1953. The 5 tests are followed, that there must be a hypothesis of guilt, a complete chain, etc., etc. It's also a case on Section 32 of the Evidence Act and scope of a dying declaration, and the fact that Section 32 is an exception to the rule of hearsay. Now, on Section 32, Mukesh is important. That is the famous Nirbhaya case, serial number 39, because in that, the court held that there can be multiple dying declarations, and that per se would not make or would not weaken the prosecution case. There can be multiple dying declarations. A dying declaration can also be the sole basis for conviction. There can even be a dying declaration through nods and gestures, and it may be admissible. Of course, in the facts of that case, it was recorded by a metropolitan magistrate, so it was given greater weightage. The court also held that videography of a dying declaration is only a measure of caution. It is not doing so does not render the dying declaration fatal. In case of alibi, the burden is on the accused to establish with positive evidence the onus as regards his presence on the spot if it's not established by the prosecution. Of course, in the facts of that case, death penalty was confirmed. The last one in my list is Mafatlal. Mafatlal is a tax case and a case of unjust enrichment, where the court held that the principles when an assessee can seek refund of tax if it is illegally collected, and what is the appropriate remedy. Of course, the test there is that if the burden has been passed on to others, that is, when if they have collected the tax and if they have collected the burden of the tax has been collected from the consumers, then of course there is no question of any refund or restitution, and therefore that principle will not apply. I think I have 2 minutes left and I've been able to finish within my allotted time. Thank you. There is one question that I find people have repeatedly put in the chat box, that which are the judgments likely to come in the exam. Surely we cannot answer that question. Mr. Gupta. Any judgments that are left out, don't forget there are 2 lectures tomorrow where the balance will be covered. So Mr. Gupta and I have only covered 16 plus 16, 32. Others will cover them tomorrow.
Thank you, sir.
Any specific question? I mean, any question? As I said, questions about what is important, what will come in the exam, I cannot answer. But I think, as Mr. Gupta possibly mentioned, the important thing is a leading case is in the middle. You should know how the case arose and what is the important follow-up or some judgments where the cases have been referred to or relied on, and where the law, it has taken the law after that. Thank you. Is that all, sir?
Thank you, sir.
Thank you. Thank you very much.
Thank you, sir. Thank you very much.
Absolutely great. Thank you.
Thank you very much, sir. Thank you, sir.
Thank you. Happy. More than 500 people here.
Sir, so great to see this great adventure, sir, of imparting the education of this lecture
I
series.
think you say we fell short of time. We should have kept at least 1 hour for each. But 1 hour, you see, people don't have so much of focus. So we should have 45. The next time, if we do the same thing, we must not have more than 8 or 10 judgments for each lecture. You see, you can't. You see, this is also what we did was we structured them into bunch. Okay, everything is they are connected with each other. तो इसे आपका जो लिस्ट बनाई आपने तो ईयर वाइज बना दी, तो वो अभी करेंगे अगर वो विल डिस्कस द इश्यूज की सिलेक्शन इटसेल्फ इज वेरी अमेजिंग सिलेक्शन ऑफ दिस नेक्स्ट टाइम विल लुक इनटू इट हाउ टू सेलेक्ट दीज केसेस एंड देन देयर हैज टू बी अ सिस्टम भाई अल्टीमेटली जो है वो वी हैव टू टेस्ट द नॉलेज मतलब जो हैं वहाँ जो एग्जाम दे रहे हैं एडवोकेट ऑन रिकॉर्ड्स उनको जो है दे मस्ट understand the judgments, able to express it and answer the questions correctly. So they must understand all these serious judgments. So picking up the leading judgment itself and then अब ये कई जो है वो उनका link नहीं है ना. That is why how we divided into 4 of us. चलो देखते हैं next time.
Right, sir.
Okay, thank you very much.
Okay.